Okay. Good morning, everyone. On this sunny Sunday morning, I hope all you are all awake. People are not yet awake. I think they are not joined. They are joining. Maybe hangover from last night's party, or maybe studying hard for their exams, whatever. Anyway, we have a brilliant solicitor today speaking for us on IBC code. A lot of experience in that matter. Mr. Nirav Shah from DSK Legal. Like yesterday, he will speak on the changes, amendments in the law, some new judgments. He will give us an insight on all that, and then we will have a question answer interactive session. Like yesterday, do not put questions on the chat. Switch on, unmute yourself, switch on your videos, and ask questions to him. So we'll have something like, I don't want him to feel that he's talking to walls. So even now, some of you can keep your videos on so that he can see you all and he'll feel that he's not talking to walls. Okay. So some of you can please switch on your videos, but keep your microphones on mute. Okay. Handing over to Mr. Nirav Shah. Nirav, welcome. Thank you on behalf of BILS for sparing your time on a Sunday morning, helping our article clerks, giving some insight on the law. Take over, please.
Thank you so much, Nilesh. I'm really grateful to BILS for giving me this opportunity to speak to these upcoming solicitors. And I hope this 1.5 hour session is helpful to all the kids in clarifying their doubts as far as IBC is concerned. What I was just telling Nilesh is the way I've kind of segregated the discussion is I will speak briefly about the amendments that were introduced to IBC last year. I will speak about certain other concepts which are highly litigated, and then I will talk about certain critical important judgments which have been given by the Supreme Court of India. Because as you know, more than the amendments to IBC, the law has actually developed and evolved thanks to various judgments of the Supreme Court. So this is how I plan to go about, and then we can have our interactive session, Q&A, etc., where I will try my best to resolve any doubts or queries that you guys have. Okay, so starting with the amendments that were introduced last year, in August 2021, the government introduced a full chapter into IBC, which basically introduced the concept of a pre-packaged insolvency resolution process. I mean, if you cut through the clutter and if you look at only what the PIRP means, it basically means that the lenders and the company try to resolve the insolvency of the company before a formal insolvency is entered into. The idea behind this is that before letting the company go into insolvency, if it's possible, if there is scope to revive the company, then all attempts must be made to revive such a company. Currently, the way the provisions stand, this pre-packaged insolvency resolution process is currently only applicable to micro, small, and medium enterprises in order to resolve their financial issues. There is a minimum threshold required there that the debt outstanding must not be in excess of 1 crore. So very specific kind of situation, MSMEs, debt not exceeding 1 crore, and before a formal CIRP is initiated, attempt must be made by the lenders and the company to try and arrive at a pre-packaged insolvency process whereby the debt of the company can be resolved, whereby someone can come up with a plan to acquire the company and resolve all the debt, when you don't need to go into the entire process of corporate insolvency resolution process. Through this amendment, the government has actually introduced an entire chapter 3A into the IBC. I will not go through each and every section of chapter 3A. It largely follows the process. It's very similar to the CIRP in as much as there is an RP appointed, the RP takes charge over the management. In order for the PIRP to go through, the company needs 66% consent of all the lenders, etc. What happens if an application for PIRP is filed, and how does the NCLT resolve that if there is already an application under section 7 or 9 or 10 of IBC for commencement of CIRP is already pending? Now the rules, the amendment to the act suggests that if an application for PIRP is filed within 14 days of the filing of section 7, 9 or 10, then NCLT must decide the PIRP application first and put on hold the other applications. But if it is filed after 14 days, then the NCLT is free to decide either section 7 or 9 or 10, whatever it may be. So it is important that if someone wants to do a PIRP, if the company wants to do a PIRP, and if it comes to know that there is a section 7 filed, it is important that an application for PIRP is filed within the time period specified under the amended code, right? So that is that. In order to commence the CIRP, you need 66% consent of the lenders. There is also section 54O of the IBC, which has been introduced, which says that during PIRP, at any stage, if the lenders believe that this PIRP is not working out, then they have the freedom to pass a resolution and convert such a PIRP into CIRP, in which case they have to go and apply to the NCLT for such conversion. Right now, a very important consideration is, when can an application for initiation of PIRP can be filed? It can only be filed in very specified and limited situation, is if the company has not undergone a PIRP or CIRP in 3 years preceding the initiation date, if it is already undergoing a CIRP, if there is no pending liquidation order, if the person submitting the application for PIRP is ineligible under section 29A of IBC. I presume all of you are already aware, section 29A of IBC provides for disqualification of any party to submit a resolution plan to acquire the company. So any person filing a PIRP must not be disqualified under section 29A of IBC. That is critical. And again, I spoke about 66% consent by all the creditors in order to commence a CIRP. Then there are certain standard forms that the directors need to file, etc. And the company needs a resolution of 75, a special resolution of 75% shareholders in order to file an application for PIRP. Now, when it comes to duties of the insolvency resolution professional, they are more or less similar to the way it goes in CIRP. There are some very minor differences. It's fine, you can actually look it up. Then what happens is, during the CIRP, during the PIRP, the company actually has to submit a base resolution plan, okay, and the same has to be presented before the committee of creditors. Now, once the base resolution plan is submitted, then anybody who wants to submit a plan must submit a plan keeping that base resolution plan in mind, and they ideally have to do better than the base resolution plan. Once anybody else submits the plan, then the lenders have the choice to either go with the base resolution plan that the company itself has provided, or any other applicant who's come up with a plan which is better than a base resolution plan. That is as far as the plan is concerned under the PIRP. And then depending on what plan the COC approves, then such a request has to be taken to the NCLT for approval of a resolution plan, very similar to the way we do it for a normal resolution plan. How is a PIRP terminated? Typically, it is terminated by NCLT passing an order terminating PIRP if the COC approves by a vote of 66%. And such an order should also provide for a manner in which the proceedings have to be continued or initiated for avoidance of transaction under Chapter 3 or under 66 or 67A of the code. And the corporate debtor shall be responsible for bearing the cost of the PIRP. We've already spoken about how a PIRP is converted into CIRP. The lenders have to approve, 66% COC have to approve that the PIRP is not working, and the same can be converted into CIRP. and then the normal process that has been laid down in the act will follow. So this is broadly one of the biggest amendment that has been introduced by the government in 2021. Of course, there is still, it's a good amendment, it's a welcome amendment, but there is a government committee report which was again issued in late last year, which one of the two or three recommendations that they have made is that the provision that was introduced by the government for prepackaged insolvency is currently only limited to MSMEs, and there is a cap of 1 crore. There is a suggestion which has come from the government committee only, which has said that this must be extended to all the creditors, because it will help prevent lots of amounts of pain and anguish, because there are times when companies genuinely run into insolvencies and then there is no fraud, there is no there's no fraud, there's no siphoning, etc. And where there is scope to revive the company, if such a provision is available, then it would really help that company come out of insolvency. But of course, currently this is only at a suggestion stage. There is no movement as of now that we know of where we believe that the government is likely to introduce such a provision for all lenders and not just for MSMEs or companies, not just MSMEs. So I would request, see, because this is one of the major amendments that has been introduced last year, less than a year ago. I would believe it becomes very important for you from an exam perspective, because it's very possible that you may be asked questions on this because of the relevancy of this, and because it is something which people are taking to in order to avoid insolvency. Now, that is as far as the prepack of MSMEs is concerned. Coming back to another important aspect which you will face is, how does the insolvency of a non-banking financial institution or a company work? All of you would have read by now in your business papers, Economic Times, Mint, Business Standard, etc. And also because it was hotly contested, is the insolvency of Diwan Housing. Diwan Housing is not a regular company, it's a non-banking financial company, and it typically doesn't get governed by IBC. There is a special provision under IBC, which is basically called insolvency and bankruptcy, insolvency and liquidation proceedings of financial service providers, and application to adjudicating authority rules. So the way in which an insolvency of an NBFC commences is very different than what it would be for a normal corporate debtor. For a normal corporate debtor, you can have a situation where a financial creditor files a Section 7 petition, or an operational creditor files a Section 9 petition, or the company itself files a petition under Section 10. As far as NBFC is concerned, typically any one of the lenders will have to write to the RBI and request the RBI to commence CIRP of such an NBFC because it is unable to pay debts, the loan has become NPA, the amount of debt is too high, etc., etc., which is what happened in Diwan Housing. And only after RBI approves such an application and appoints an administrator who effectively acts like a resolution professional, then only in such a situation an insolvency of an NBFC can commence. You will see, if you look it up on the main order and judgment as to how Diwan Housing insolvency commenced, this is how it commenced. And more recently, it is another NBFC that is a Calcutta-based Shrey SREI has also been referred to insolvency by the RBI. So it has happened. There are many more applications that have been made to the RBI for commencement of insolvency of NBFC, but RBI has been extremely selective in taking NBFCs to insolvency. DHFL is a classic case. Shrey is also a classic case. There have been, I am aware of some other instances where NBFCs have been, RBI has been requested to commence insolvency for NBFCs, but RBI has not budged. But let's not get into that because that's not relevant for our purposes. The ones that we know of is DHFL and Shrey. So yeah, I'm pretty sure you would have probably read up on that. Another important aspect, which is more practice related, is once a CIRP commences, what happens if you want to withdraw the if you want to withdraw the CIRP, parties want to settle the matter. Can anybody tell me in what ways can this happen? If you want to withdraw the CIRP, parties want to settle after commencement of CIRP. Anyone?
Please switch on, unmute yourself and
Yeah,
answer.
I'll be happy to take answers. It will be quite interesting.
We have to have this an interactive session.
So can anybody tell me, once a petition is admitted, whether be it under 7 or 9, how can the CIRP be ended, and how can the matter be resolved?
This is Anushka Merchant.
Yeah.
Under Section 12A, the creditors, if 99% of the creditors approve, then they can withdraw the application.
Quite right. Good answer, Anushka. Now your answer says that 90% of creditors have to approve withdrawal. What happens if the settlement takes place before a COC is formed? There is a very slight nuance. I know your answer is right. There's no difficulty. But what happens if this settlement has to happen before a COC is formed? In that, okay, I'll just give the answer. In that case, what you need to look at is Regulation 30A of CIRP regulations. This is very important, because what happens is, I'm telling this to you from a practical experience, is that when a petition is admitted, all of a sudden the promoters will start running around, try and arrange funds and try to resolve the matter. And the rush always is that they want to settle before a COC is formed, because Regulation 30A only requires the RP to file a Form FA with the NCLT, and which sets out how the money, who is going to pay the money, how the money is to be paid, and how the settlement happens. In that situation, you don't need 90% consent, because your COC has not been formed. Because the minute a COC is formed, it is going to be an uphill and a Herculean task for the promoter to get a 90% consent, because invariably, unless the number of lenders is limited, there have been instances where the number of lenders is 25, 30, 35, 40. In such a situation, it is very hard to get 90% of lenders on board, which is why, practical perspective, it is very critical. A lot of promoters run around immediately once a petition is admitted to try and settle the matter before a COC is formed. So just keep two things in mind: settlement before COC is formed and settlement after COC is formed. Before COC, look at Regulation 30A of CIRP regulations, and after COC is formed, 12A of IBC, which is what Anushka mentioned, read with Regulation 30A of CIRP regulation. So just keep this little nuance in mind, because this is, if somebody wants, if an examiner wants to trick you, he might ask you this trick question. Okay, so that is as far as withdrawal is concerned. I would just also like to point out that there are like n number of judgments that have come, which have categorically stated that Limitation Act applies to proceedings before IBC, and that's a settled position. So yeah, so I would now like to go into certain Supreme Court judgments which have dealt with many issues. I presume you would have all been familiar with the landmark judgments of SR Steel and Swiss Ribbons and Innovative Industries, etc. These are all landmark judgments which have held at various points of time and reinforced what the IBC provisions is. We will not go through all of them, but some important ones, judgments which have come in the last 1.5, 2 years, I'll just take you through that. Okay, so one common question that always comes when a party files a Section 7 petition, and this is something which I also did recently, and I was faced with this problem, is a Section 7 petition has been filed without annexing any transaction documents. There's a loan agreement, there's a deed of mortgage, there's a deed of hypothecation, there's a pledge agreement, there's a guarantee agreement. There are like 15 transaction documents are there pertinent to the loan. I have not annexed any document to my Section 7 petition. All that I have done is there is a acknowledgement of debt given to me 2 years back to back. There is a balance sheet, and there is something called as information utility report, IU reports, which I have annexed. Now the question that came is, because the transaction documents have not been annexed, is my Section 7 petition defective? And I mean, the reason I did not annex these transaction documents is all the documents were executed outside the state of Maharashtra. The minute I bring these documents into state of Maharashtra, all of them attract stamp duty. And the stamp duty in Maharashtra is exorbitantly high. And not only will I have to pay stamp duty, I have to pay penalty on the stamp duty because documents have not been stamped. So it's a conscious call that we took that we will not bring in these documents. And this was hotly contested in 2 of my cases before the NCLT. And eventually we succeeded. Relying on 3 Supreme Court judgments in the case of Mobilux Innovations versus Kirusa Software, Swiss Ribbons, and Innovative Industries, which all 3 of them have categorically held that on a fair reading of IBC, all that the adjudicating authority is supposed to look at is whether a debt is due and payable or not. Once the adjudicating authority comes to that conclusion, they are not supposed to look at anything else. And in order to ascertain whether a debt is due and payable, a balance sheet is a good document because balance sheet discloses what the debt is. Acknowledgement of debt is a good document. And most importantly, this is one document that has been recognized by the IBC itself, is information utility reports. Now, these information utility agencies were not set up till a couple of years back, but since 2020, they've got their act together. Now, the IU reports can only be generated by the information that the lenders share with the information utility agencies. Once the lenders share the information, you have to just request the information utility agency to generate a report for an indebtedness of a company. The report that gets generated, you can annex it to your petition, and that is an admission of the fact that the debt is due and payable, number 1, and number 2, that a default has occurred. And the proof of the default is only IU report and nothing else. So these 3 Supreme Court judgments, Mobilux, Swiss Ribbons, and Innovative, have categorically held that once an IU report has been placed on record, the tribunal adjudicating authority doesn't need to go or look beyond and for any other document. So just keep this thing in mind, that you will have a situation where if you believe Section 7 petition doesn't have any document, the one thing that you need to be mindful of is, does it contain IU reports? Does it contain acknowledgement of debt? Does it contain balance sheet which evidences that the debt is due and payable? If it does, then you're safe, there is no difficulty. Okay, so that is as far as the information utility report and admission of debt is concerned. Okay, second, a very important issue that came in the insolvency of one of the telecommunications company is, can an asset reconstruction company be a resolution applicant? Can an ARC submit a resolution plan to acquire any company? Various arguments were made by various parties, and net, the answer is that 1, there is no bar under the IBC from ARC to submit a resolution plan. In fact, Section 29A of, you can look this up separately when you're studying. Section 29A of IBC categorically provides a carve-out for resolution plan to be submitted by ARC in 29A. 29A itself is a section which talks about which party is disentitled to submit a resolution plan. In this negative section, there is a specific carve-out for an ARC which states that an ARC can submit a resolution plan. There is only one caveat which basically came around during the time the telecommunication matter was going on, is when the government said that the ARC must not subscribe to the equity of the corporate debtor. So what happens is, in a lot of cases, ARCs are indeed submitting resolution plans, but they are in fact putting forth either certain individuals or corporates to actually subscribe to the equity, and the ARC will stand behind such a people who are subscribing to the equity. So ARC themselves will not subscribe to the equity, because that is something which became a contentious issue as far as the insolvency of the telecommunications company is concerned. So the issue that I'm trying to highlight is a resolution applicant, an ARC can be a resolution applicant as long as it is not subscribing to equity shares. There is a specific carve out given for resolution plan submitted by the ARCs under 29A itself, and there is no bar otherwise in IBC or any government or RBI regulation which prevents ARCs from submitting a resolution plan. Now, another very tricky proposition was raised before Delhi High Court is, once a resolution plan is approved, what happens to all the applications that have been filed by the resolution applicant for fraudulent transaction or for a clawback or for transactions which have resulted in losses for the company, etc. All transactions typically that an RP would file under 43, 44, 45, 47, 49 and 50 of the IBC. What would happen to all these applications? Can anybody take a guess? I'm talking about a situation where all these applications are pending before NCLT and the NCLT has approved a resolution plan. So the CIRP has ended. Anyone?
Those plans can be disposed of?
No, disposed of means what? Disposed of can mean, are they allowed or dismissed, or they're or what? Disposed of can mean the either applications are allowed or they're dismissed or they are just withdrawn, whatever. What do you mean by disposed of?
I mean, depending on the resolution plan which is approved, on the basis of that, if it's allowed, the other applications might get attached to those resolution plan.
No, resolution plan will not contain anything pertaining to these applications of the RP. Resolution plan essentially is what? It's a plan whereby one person comes and said that I will take over this company on these 10 conditions. I will bring in so much money, and the money that I bring in, you distribute amongst all these lenders, and it will show that the resolution plan is in compliance with section 30 and 31 of IBC. That's all the plan will show. The plan will not talk about the applications that are pending before the NCLT for avoidance transaction, fraudulent transaction, etc., or any clawback provision.
This is Anushka.
Yeah, Anushka.
I'm not sure, but does the corporate debtors liability cease once the resolution plan is approved in case of these applications as well?
So that's a good answer, but not a complete answer. But yes, you are thinking on the right lines, Anushka. So the thought process is that once a resolution plan is approved, the CIRP has ended. All contracts which were entered into previously by the corporate debtor have ended. So now you cannot expect a new management, a new company to continue with those applications. Now that is what Delhi High Court has held. I am not so sure if that's the correct position, but now as it currently stands, the Delhi High Court judgment holds forth. And the Delhi High Court has said that these applications, as per the language of the code, have to be prosecuted by the resolution professional. Once a plan is approved by adjudicating authority, the resolution professional becomes functus officio. He is no longer holding the office of a resolution professional. As a result, all such applications automatically come to an end. All right. Now that I'll just give you guys the name of the judgment. If you want, I mean, if it's of any interest to you, you can look it up later on. It is Venus Recruiters versus Union of India. It's a Delhi High Court judgment. Personally, I'm not entirely convinced, because you are effectively letting the fraudulent promoters go scot-free, and it basically just allows them to wash away all their sins just because a resolution plan has been approved. So I believe that can't be the intent, and unless there is a one way to get out of this is, like Anushka mentioned, is that you can consider keeping a specific carve out into the resolution plan, giving the freedom to the resolution applicant to continue with these applications and bring the money back to make the company whole. That's an option, but it's not yet been considered in any such resolution plan as such. And so again, this is again up for discussion. One similarity which I can think of, and which issue arose from the insolvency of Arcom, is the resolution plan that was approved contained a specific carve out that over and above whatever money that the lenders are getting under the resolution plan, the lenders would be free to pursue the personal guarantors for the money that is owed to them by the guarantor. So despite the fact that the CIRP has come to an end, and as expected, the lenders have almost taken 85-90% haircut under the resolution plan, which means that they still have to recover significant amount of money. And that carve out under the resolution plan allows them to go against the personal guarantor to recover the balance money. Now, of course, they will not be able to recover the balance money because the guarantor himself doesn't have that kind of money. But coming back to these fraudulent applications, undervalued transactions, etc., and to get the clawback from the promoters, one option which is there is that the resolution plan itself contains a carve out that the resolution applicant, once his plan is approved, once he takes over the company, he must have the freedom to claw back these monies from the former promoters. If that provision is there, then maybe these applications can be continued. But currently, as things stand, the Delhi High Court judgment holds fort, and once a plan is approved, all such applications have been filed for fraudulent transaction, undervalued transaction, automatically come to an end. Right? So that's as far as that is concerned.
I have a query.
Yes, please tell me.
Sir, in this case that you're proposing that that the RP itself has to make the application, right?
Yeah.
These transactions. So in case the resolution plan is approved, the RP will not be able to pursue these applications. So if at all something like this has to be done, there will have to be a provision for the creditors itself to make these applications, or the company to pursue these applications.
Correct. Creditors, not so much, because once the creditors receive the money under resolution plan, effectively it is a full and final settlement for the creditor.
Correct.
So, but yeah, you're right. It's possible a carve out can be made either for the creditors or for the resolution applicant who is now going to step into the company and take over the company.
Correct.
Yeah, so that depends how, if the carve out is there,
modified again.
Whose favor will it be? How will it work? Is something that has not yet been seen, but I guess we'll see it in the coming times.
Okay. Thank you.
Yeah. There are some comments. I'll just see what. Yeah. Okay. Anuj has put up the citation on Venus recruiters. Thanks, Anuj. So if anybody is interested, you can have a look at that judgment. Then, okay, another interesting aspect that has come up is what would happen if a winding up petition is pending before High Court, and then a Section 7 or Section 9 petition has been filed. So the Supreme Court has dealt with this issue in the case of Naveen Chandra Steels versus Shrey Equipment Finance Limited, where they have categorically held that pendency of a winding up petition by itself is not good enough to bar a Section 7 or a 9 petition, because a proceeding under Section 7 or 9 would first normally override any other pending provision on the Companies Act. But there is one caveat. It says that a petition is not barred so long as the winding up proceedings have not reached irretrievable or irreversible situation, which means if, say, for example, the High Court, the petition is admitted and a liquidator is appointed, and the liquidator has taken charge over the assets of the company and has started selling the assets. In that situation, the circumstances for the company have reached a situation where a Section 7 or a Section 9 petition makes no sense. The rationale for this is this, that under the earlier regime, under the Companies Act, when a winding up petition is filed, it can either be admitted or it can be dismissed. If it is admitted, an official liquidator, a provisional liquidator is first appointed, who then subsequently becomes an official liquidator. and he takes steps to liquidate the company. Now, under IBC, there is a whole new stage that has been introduced, which is the CIRP stage, Corporate Insolvency Resolution Process, which means that the resolution professional has 330 days in order to resolve the debt of the company. The RP, the resolution professional, will try and see if he can find a buyer for the company. The RP will run the company as if it's a going concern. He will try to, whatever is required, the factory key will keep running. He'll keep paying the employees to the extent possible. To the extent possible, he'll try and service the debt, etc. And he will try and find a best possible solution for the lenders and to see if he can find a buyer for the company. If the resolution professional fails in getting such a buyer for the company, then and only in that situation, the company will go into liquidation. Now, what happens is, if a winding up proceeding is pending and the liquidation proceeding has commenced, then you have actually reached the stage which is irretrievable and irreversible. And there is no scope for the NCLT or the resolution professional to go through the entire motion of a CIRP, which is why the test laid down by the Supreme Court is, so long as the winding up proceedings have not reached a stage which is irreversible or irretrievable, a Section 7 or a Section 9 petition before NCLT is maintainable and can be entertained. So in that case, it is NCLT which will have jurisdiction. It is NCLT which will hold forth, and the order of admission will hold over and above whatever is happening in the High Court. And naturally, once a petition is admitted by NCLT, High Court will typically hold its hand and not do anything further, because it is NCLT that has the jurisdiction and not the High Court. So that is as far as the pendency of winding up is concerned. Then okay, that's fine. Okay, one very interesting issue came up, and this matter was done by one of my colleagues, is a Supreme Court judgment in the case of Indus Biotech versus Kotak India Venture Offshore Fund Limited. Now, what has happened is, in this matter, a Section 7 petition was filed. Before a Section 7 petition got admitted, the company filed a Section 8 application under the Arbitration and Conciliation Act. And then the issue that came before the tribunal is, once a Section 7 petition is filed, an application under Section 8 of the Arbitration and Conciliation Act, which all of you are already aware, is to ask the tribunal to refer the parties to arbitration. So the objection taken was, such an application before NCLT is not maintainable. The matter was heard. NCLT allowed the Section 8. It went from NCLAT, it went from NCLT to NCLAT, and eventually to Supreme Court. Now, Supreme Court has held that till such time a Section 7 petition is admitted, the proceedings between the two parties are in personam proceedings. Once the Section 7 petition gets admitted, the proceedings then become in rem, which means that it is not just the interest of the petitioning creditor, but it is the interest of all the creditors, all the stakeholders who are involved are now at stake and are now involved in this matter. The distinction made by the Supreme Court is, till such time the proceedings are in personam, a Section 8 application is maintainable, and NCLT must decide that in favor of the party which files a Section 8, and the parties must be referred to arbitration. And the sole reason for that is that the proceedings continued to remain in personam and they had not become in rem by virtue of admission of the petition. So this is an important judgment. This could come in, this could be very helpful. It is, I mean, if you want to take down the name, it is Indus Biotech Limited versus Kotak India Venture Fund. I can give you the citation: 2021 6 Supreme Court cases, page 436. Right. Then another most obvious judgment of the Supreme Court, which I'm sure all of you already know, is Ghanshyam Mishra versus Edelweiss Asset Reconstruction Company. It holds pretty much the same thing, that once a resolution plan is passed by NCLT, the same is binding on all the stakeholders of the corporate debtor. It is binding on the employees, it is binding on the lenders, operational creditors, financial creditors. It is binding on all the companies and parties who have a contractual arrangement with the company. So nobody can claim any exception, and whether you like it or not, such a resolution plan is binding on all the parties. Now we come to one of the more debated and argued issue in the case of Lalit Kumar Jain versus Union of India. Again, this judgment was passed last year, and this was passed in a batch of petitions which were filed before the Delhi High Court, challenging the rules introduced by the government of India only with respect to personal insolvency of personal guarantors. Now, if you see section 60, subsection 2 of the IBC, it provides that an insolvency against a personal guarantor can be invoked so long as the main corporate debtor is in CARP before the same NCLT. So, for example, if the corporate debtor is in the insolvency is going on before Bombay NCLT, and the personal guarantor, say, lives in Ahmedabad. So in order for you to initiate a personal insolvency against the guarantor, it is the Bombay NCLT where you have to come to invoke the personal guarantee and personal insolvency. Now these rules were challenged by lots of personal guarantors, including the famous personal insolvency of Anil Ambani, and they challenged the constitutional virus of these rules. Eventually, the IBBI filed a transfer petition to Supreme Court and got all the matters transferred to Supreme Court. And Supreme Court has basically held that they basically said that the validity of the impute notification is not ultra virus, and the rules that have been introduced by the government would be are constitutionally valid. It also said that as long as there is an option available for a lender to proceed against the personal guarantor, there is no bar against the lender from initiating personal insolvency. Again, in this situation, it is the resolution plan which contained a specific carve out that over and above what the lenders get under the resolution plan, for any of the other unpaid debts, they are free to go against the personal guarantor. So this actually has examined the constitutional validity of the rules introduced by the government. So this is an important judgment, and this you must know as far as you're from an exam perspective. There is another judgment of Lakshmi Pat Surana versus Union Bank of India, which basically says that if there is a corporate guarantor who has guaranteed a debt of a corporate debtor, then as long as the corporate debtor, the debt becomes due and payable, the lender has the freedom to go either against the corporate debtor or the corporate guarantor. If the lender so feels, the lender can completely ignore the corporate debtor and go straight against the corporate guarantor if it believes that the corporate guarantor has deep enough pockets. So there is no bar, there is no requirement, or there is no limitation that the lender must first go against the corporate debtor, and only if the corporate debtor fails to pay, he has to go against the corporate guarantor. So Lakshmi Pat Surana's case, the Supreme Court has said that's not the case, and the lender is free to go either against the corporate debtor or against the corporate guarantor. Okay, and another interesting aspect that came about is in the case of P. Mohan Raj versus Shah Brothers Ispat Private Limited. And the issue here was that the moratorium under section 14 of IBC, will such a moratorium apply to proceedings under 138 of the Negotiable Instruments Act? Now, as we all know, I mean, at least as we all understood at that point of time, is that the section 14 moratorium only typically affects civil proceedings, civil recoveries like regular suits, arbitration, etc., against the corporate debtor. But what the Supreme Court has done is they have basically said that we all know that the section 138 proceedings are largely intended to recover monies from the company, and Supreme Court has held that since that is the case, this section 14 moratorium would apply to proceedings under section 138 of the IBC. Now, section 138 proceedings are strictly speaking criminal in nature. But having said that, this is a Supreme Court judgment and it holds the fort, and the moratorium would apply to such a proceeding. Now, another important aspect is Section 29A of IBC, which talks about disqualification of parties from submitting a resolution plan. Now, in the case of Arun Kumar Jagatramka versus Jindal Steel, Supreme Court examined this issue, that in what all situations can 29A apply. So one, it is very clear that it's a disqualification as far as the resolution plan is concerned, and any party who is disqualified from submitting a resolution plan on 29A cannot present the resolution plan. In this judgment, the Supreme Court was concerned with whether a party who is otherwise disqualified from submitting a resolution plan, can such a party file a scheme of arrangement and amalgamation, a scheme of compromise before NCLT under liquidation. Right now, liquidation, there are multiple modes of liquidation that's possible. If you look at the IBC, the liquidator can either sell the company, sell the assets of the company piecemeal. The liquidator can either sell the company as a whole, as a going concern, or you can do a scheme of compromise and arrangement. They're all three possible. There are 5 or 6 options available, but largely it is these three. And the issue before the court was whether such a scheme of compromise, would such a scheme be permitted if it is given by a person who is otherwise disqualified under 29A to submit a resolution plan. Now, Supreme Court has categorically said no. Basically, allowing such a person to submit a scheme for compromise would in effect mean that you're handing over keys to the company to the person who is responsible for driving up the company in liquidation. So the regulation, the principles of 29A would be applicable not only during CIRP but also during liquidation. It also applies when there is a section 33 or 35 of the code also specifically talks about in what situation this will apply. Either if you look at section 35, either sale of movable assets, immovable assets, or any other sale. It cannot be done, sale cannot happen to a person who's otherwise disqualified 29A. And this particular judgment in the case of Arun Kumar Jagatramka versus Jindal Steel, it has decided this position and said that such a person who's disqualified 29A cannot present a scheme of compromise before the NCLT. Yes, another critical issue that came up before the Supreme Court in the case of Gujarat Urja Vikas Nigam versus Amit Gupta is, does NCLT have power to stop the termination of contracts? Answer is yes. Under section 14 of the IBC, the NCLT and NCLT have the power to stay the termination, but the Supreme Court has caveated this to say that while the power of the Supreme Court or power of the NCLT and NCLAT is there to stay the termination, it cannot go beyond that, and it cannot usurp the jurisdiction of a civil court or an arbitrator, which otherwise it would decide in case a dispute under such a contract would arise. So the Supreme Court has in that sense kind of defined the extent to which an NCLT or NCLAT can go as far as termination is concerned, and they've said that the only thing the NCLT or NCLAT can do is to stay the termination. Yeah. Now, all provisions of limitation act, we've already discussed that. Now, this actually an issue which has arisen a lot since the time COVID has happened. Because of COVID, there was an initial period of lockdown which went on for quite some time. So a lot of parties who had submitted resolution plans and whose resolution plans were approved by COC and they were pending adjudication before the NCLT, a lot of these parties started withdrawing the plans. They said that because of COVID, my vision that I had for the company is not the same anymore. The plan is not feasible. The plan is not viable. during COVID, so many number of contracts were terminated, the business has gone down, this happened, that happened, etc. And they started applying to NCLT for withdrawal of resolution plan. Now, one such couple of matters that we were doing were in NCLT Ahmedabad, NCLT Bombay, NCLT Hyderabad. In some instances, they allowed withdrawal, matter reached NCLAT, and eventually one particular matter reached Supreme Court. That was in the case of EBIX Singapore Limited versus COC of Educom Solutions and another. In this judgment, the Supreme Court has categorically held that the principles of Contract Act cannot be introduced as far as an approval of a resolution plan is concerned. It is not a situation where there are reciprocal promises to be performed by the resolution applicant on one hand and the COC RP on the other hand. There is no promises, there is no reciprocal promises, there is no performance issue. Once a resolution plan is approved by the COC, the RA cannot withdraw the plan. The IBC contains no such provision, and as far as IBC is concerned, the only issue that then will remain to be decided by NCLT is such a resolution plan in line with IBC or not? Does it comply with all the tests laid down by the IBC under section 30 and 31 of the code and the CIRP regulation? Once that test is met, the NCLT has to either admit or reject the resolution plan. A resolution applicant has no power, or the IBC contains no provisions which allows any resolution applicant to withdraw the resolution plan. So this is an important judgment. You can take it as EBIX Singapore versus COC of Educom Solutions. It's an important development in law. We've already spoken about Lakshmi Pat Surana. Then we talk about, you already must have known about SR Steel Limited. It has held various things. One of the things it has held, that the CIRP of a corporate debtor must be completed within a period of 330 days, and the parties must endeavor to ensure that the CIRP is completed within 330 days, and only in exceptional circumstances this time period can be extended, but not otherwise. So that is in the case of SR Steel versus Satish Kumar Gupta. Another important judgment is K. Shashidhar versus Indian Overseas Bank, and there are many judgments which have followed that, which have clearly held that NCLT and NCLAT cannot sit in appeal over the commercial wisdom of the COC. The commercial wisdom of the COC must be given primacy, and NCLT can only look at the procedural aspect and just see whether the plan is in line with IBC. Beyond that, NCLT or NCLAT cannot go and inquire why COC went with A plan and did not go with the B plan, whether more money was received under A plan or B plan. That inquiry NCLT or NCLAT does not have jurisdiction to enter into. So you will find many judgments on this. One is K. Shashidhar versus Indian Overseas Bank, and subsequently this line of judgments has been followed consistently. So that, as far as the commercial wisdom is concerned, that law is fairly clear. So I think from my side, I'm what I wanted to cover, I've broadly covered. If there are any questions, I'll be happy to answer.
So now we'll have the question answer session, and I would request all persons one by one, you can ask questions. Please switch on your video, unmute yourself, and then ask questions. That will be better. Let's have a more interactive session here, and then we'll close the session completely.
So, hello, sir. I'm Rucha.
Yeah.
I had two doubts actually.
Yeah.
One about the finality of the resolution plan once it's approved. So there was a case asked, like a situational asked in one of the papers, where it was asked that ABC is an operational creditor, and after the resolution plan was approved, in the resolution plan, it was written that claims are subject to disputes pending before various authorities have been verified with a notional amount of ₹1.
Correct.
So
I'll tell you what happens is, invariably, when a resolution plan gets approved, there is a hierarchy under section 53 of the code as to how the payout has to happen. Invariably, operational creditors get nothing because the financial creditors themselves, who are secured creditors who sit on the COC, invariably they either end up taking a 80% haircut, 90% haircut. So the money that comes in through the resolution plan, that money is not good enough for financial creditors itself. If that is the case, then it is very difficult for the operational creditor to get anything out of it. So what they do is sometimes operational creditors, they have arbitration pending, they have a suit pending. So depending on the outcome of that, if they win, then their claim would be valued at 1 rupee. That's typically all resolution applicants provide for that in their plan. It is just for the purpose of ascribing a value to that claim. It actually speaking, the claim is zero, because if you look at the waterfall mechanism under 53, the operational creditor is not going to get anything from the resolution plan. I don't know if that answers your question.
So the earlier matter that was pending, and then there was moratorium imposed, so that is why it was stopped. So that would be revived.
No,
and
no. I mean, you can revive it, but the claim, it's not. What are you fighting for? Because once the plan is approved, and even if you get a decree in your favor, you will not be able to execute the decree. So then, why would you want to continue?
Okay, so then what can the operational creditor do? Nothing.
Quite frankly, there's not much operational creditor can do.
Okay. Because there's a question: what advice would you give the operational creditor?
That's a tough one. Because to be very frank with you, under the plan, the operational creditor is not going to get anything. That's a reality. So, one option is the operational creditor can continue with the litigation, keep spending time, effort, and money after his lawyers. But if at the end of the day, if all that he's getting is 1 rupee, then do you want to spend good money after bad?
Probably the person who has asked this question in the exam wants to know whether he can go and file some kind of claim form or something with the IRP or maybe the liquidator later on.
Yeah.
Like
no, that's true.
We had in the winding up earlier.
True.
Go and file a claim with the liquidator. So
No,
something like
that claim typically, I think from what I understood from her, is that claim has already been filed, but it has been made subject to outcome of the litigation. So you don't know whether that operation creditor has succeeded or not. But presuming the operation creditor succeeds, all that he's going to get is 1 rupee. Because even if he has a decree in his hand, he'll not be able to execute the decree. I hope that answers the question, Rucha. I don't know if I answered it or not.
Yes, sir, it does. And so there's one more question so it seems to be a straightforward question, but then some people said it's not. So the question is, can a financial creditor in respect of whom there is no default file an application for CIR?
A financial creditor in respect of whom there is no default? Creditor has no default. Why would creditor default?
In respect of whom there is no default.
Okay. An FC can always file an application, no?
But there is no default in respect of me.
So if an FC has to recover money, but you're saying the money is not due.
The money is not being defaulted on.
No, then you can't. No, then the application is premature.
Yeah. But
you have to see, look at the definition of financial debt in IBC. That will give you an answer.
But under that, there is an explanation also.
Yeah.
Which there is an exception which talks about in financial debt. It says that the project, if real estate projects are.
No, but pending, then that would presume a default. Real estate projects also, you can take a real estate company, and if there are certain number of allottees who have booked flats, and either it's 10% or 100, whichever is lower, I think. I don't recollect. But if they can come together, they can actually initiate, because that initiation can only happen if there's a default. If the builder who's promised them delivery by a certain date and the delivery doesn't happen, then that's a default.
Okay, then that comes within the definition of default.
Absolutely.
Okay.
So I have a question in respect of the same question she asked right now.
Yeah.
So under section 7.1, subsection 1, there's an explanation which says that for the purpose of this subsection, a default includes a default in respect of a financial debt owed not only to the applicant financial creditor, but to any of other financial creditor of
Correct.
the corporate debtor. So I just wanted to know, does that apply to this question?
No, 1 second. Which section you refer
Section 7, subsection 1, explanation.
7.1 explanation. Okay, just give me 1 second. Sorry, I'm just trying to find the damn. For the purpose of this section, a default includes a default in respect of financial debt owed not only to the applicant financial creditor, but also correct. So even if a debt is due to somebody else, this can be maintainable. But important thing is there is a default. See, I'll tell you, in a lot of lending documents, you have cross default provisions, which means that I owe you money. You also are supposed to have, you've also borrowed money from other lenders. If you commit a default against any other lender, that will be deemed to be default, and I have the right to immediately call upon the entire money.
Okay. So that means that if there is a default in respect of any financial creditor, even if it's not in respect of me, I can go ahead and
a lot of these lending documents have cross default clauses.
Sir, but in the absence of such a clause, can you still file an application on behalf of
this explanation gives you the assistance, no?
Correct, sir. But then if there is no default as such against you,
there is no default qua you, but there is default in general.
Okay, so how then your petition only has to show the
your petition only has to show default, no?
Okay, sir. If your petition doesn't show default against you but against somebody else, then
you have to make out in your petition that the default has occurred qua ABC.
Okay, sir. All right.
So can you throw some light?
The default restricted
rights?
I'm sorry.
Vis-a-vis IBC.
Could you repeat the question, please?
Can you throw some light on home buyers' rights vis-a-vis IBC?
Yeah. So home buyers, home buyers' rights are typically similar to the rights of debenture holders, etc. They can come together at least either 100 or 10% of the allottees, whichever is lower. They can start IBC proceedings, and as far as the COC is concerned, they have to nominate one person who will represent the interest of all home buyers, and they have a seat at the table of the COC, and they can decide as far as the home buyers is concerned how they want to vote on a particular issue or an event or a resolution plan.
In such cases, what is the nature of default? Is it the date of possession in the agreement for sale?
It could be date of possession. It could be sometimes either there is delay of possession. Sometimes it's it takes years and years together for a builder to even start the project. I think Nilesh will probably be in a better position to comment on that, because that's his area of expertise. But yeah, it could literally be anything. Sometimes even real estate builders, they take loans from financial institutions to fund the projects, and then they default on that.
What they are trying to actually ask is that home buyers basically do not have any financial recoveries. It's the house that they are getting. Correct. And there is a default in getting their house. Then what happens? Is it different from financial recovery? They do not terminate their contracts and do not ask for refund of monies with interest. If they ask for that and there is a default of that, yes, maybe you can go.
But typically when in home buyers, when they do these agreements, typically there is a clause that in case of delay, some percent of interest will be paid by the builder. But
that's under RERA itself.
Correct. But you can initiate CIRP also. You can initiate CIRP also, because that is time value of money, and there is a certain number of home buyers that need to come together and initiate insolvency.
So in RERA, basically you can go individually, but in case of
you need to go as a group in IBC. In IBC, you need to go as a group.
They have to go as a group. That could be one of the questions which can be asked in the papers.
Sir, but when you read the RERA provision with the IBC provision, is it
Yeah.
only when you demand for this refund of your money can you actually term yourself as a financial creditor, or when you want
You don't need to demand. You can just straight away go to IBC.
you can directly go without making?
Yeah, you don't need to see. That's the distinction between section 7 and 9. Under section 9, you have to give a notice and you have to wait for him to respond. Section 7, there is no requirement of notice. You can straight away go to IBC.
Yes, sir. Correct.
So can you please shed some light on the stamping of
Sorry,
an
there is some
resolution?
disturbance. There's some disturbance, Hina.
Sorry, sir, I'm actually in a function. I'm sitting outside.
Okay, okay.
See, I'll type out my query.
Yeah, okay. You type it out. I'll have a look at it.
In the meanwhile, somebody else can possibly ask a question.
Yeah, somebody else can ask and we'll happy to respond. In the meantime, we'll get the question on the chat box.
Hello,
Yes.
my name is Reshma, and
Yeah, hi, Reshma.
in my second year of my 3-year clerkship, and I have a question on resolution applicants and resolution plan. So
Okay.
it's sort of a twofold question, and my first question is that can a person submit more than one resolution plan? Now, the reason why I use the word person and not a resolution applicant is because practically I understand for the purposes of CIRP, there often happens that there is only one or two resolution applicants who are working together, who often have back-to-back arrangements with third parties. In a situation where only if a resolution plan is approved, and if I am a successful resolution applicant, only then perhaps I have arrangement with 3 or 5 other third parties to sort of revive this company as a going concern. Now, that is why the first question was, can a person submit more than one resolution plan, whether he's a person as a third party or whether he's a resolution applicant himself. And the second question is again building on the back-to-back arrangement that I spoke about, in the sense that if I am a back-to-back buyer of an asset or the equity of a company, then do I also have to meet the eligibility criteria which are laid down under section 29A? And the reason why I'm asking this question is because logically speaking, if I have to think about it, I have a resolution applicant who has agreed to take on the responsibility for revival of this company. He is giving the guarantee that he's meeting all the eligibility criteria. Once he is the successful resolution applicant, whatever arrangement that he may have with the back-to-back buyers, those buyers may not be subjected to that because there's already a face of a resolution applicant. But because there are still these third-party buyers who are eventually ending up with perhaps the equity or asset of this entity, then could this also be a situation where they also would have to meet the eligibility criteria? So these are my twofold questions.
Okay, it sounded like fivefold questions, but I will try and answer them to the best of my ability. So firstly, let me address your first question is that I have not heard of one person applying for 2 resolution plans. Okay, because when a resolution plan is submitted, you have to submit the plan with everything in it in terms of if the plan goes through, whatever money you're giving to the resolution professional or the lenders, how are you going to raise the money? Are you going to get your own money? Are you raising finances? If you're going to raise finances, where are you raising finances from? What is the status of your financing, etc. So it is, I mean, it's not written in IBC that one person can't submit 2 resolution plans, but it is impractical for one person to submit 2 plans because he's competing with himself, right? So if you are serious about a company, then you put together your plan. If typically either one person can do it himself or he's doing it in consortium with other people or a company is doing it, whatever you do, you put your best foot forward. You put your best possible plan before the COC and you make a presentation and you hope that COC likes your plan. Because the one thing that COC looks for is under a resolution plan, how much money am I getting? I mean, the resolution plan sometimes runs into hundreds of words, but net everybody is looking at it just one thing, but how much am I getting out of this? Okay. So ideally, if you're putting 2 resolution plan, you're actually kind of reducing your chances of being taken as a serious contender. So I have not seen in my limited practice, I have not seen one person put 2 resolution plan, because obviously people, if he does that, then the first thing the lenders will ask you before a plan is taken is, you please decide which plan you want to submit. because we'll consider only one plan from you. Okay. Second is, sorry, what was the second part of your question?
It was on the back-to-back arrangements and the eligibility of any third-party buyer.
Eligibility of third-party buyer vis-a-vis
In the sense, in a resolution plan, it could happen that a resolution applicant could be only one party, and he would have a back-to-back arrangement with several other third parties.
Yeah.
So, do these third parties who are not exactly the face of the transaction,
Yeah.
do they also need to meet the eligibility criteria?
Actually, 29A is not an eligibility criteria, it's a disqualifying criteria.
Qualification, yeah. Do they need to not fall within
No. So, ideally, answer to that is no. The person who is a resolution applicant, the person who is going to put the money in, and the person who is going to run the company, if that is known to everybody, then whatever arrangement he may have, those people don't need to be, need to be disqualified under 29A. So that also is one reason why, this is one of the criticism of IBC is that a lot of promoters are putting in fronts to acquire their own company, and they're acquiring their own company for pennies to a dollar. So that is of course is happening. But if they continue to remain in the background throughout the time when the plan is implemented and the company is taken on, the company is up and running, then I guess it should be fine. So Hina, I've answered your question. The resolution plan doesn't need stamping.
Then said that suppose it's an approved plan, then what? Her next question is there.
Approved, again, plan as such doesn't need stamping. If under the plan, if something needs to be done for moving the company, from moving the asset from one place to another, then a standard stamp duty will apply, but nothing on the plan as such.
Okay, thank you so much, sir.
Can you throw some light on Companies Act 1956, which still holds, which is as in force, is still there in relation to winding up of companies?
Yes.
With relation to IBC?
The only ground which has been taken away from the Companies Act is the ground of inability to pay debt. All the other grounds that were there under the erstwhile Companies Act 1956 still remain. And even as on date, there are high courts which are entertaining winding up petitions. So those provisions continue to apply.
Okay, thank you.
Any more questions? So somebody also wanting to ask questions on some company law yesterday.
Okay.
I don't think so. He's joined.
I see.
Is there someone? I don't think so. Any more questions? Seems that the girls are more intelligent.
Yeah, I know. I think all questions have come from girls. Yeah,
boys are
they're
just
the ones
silent.
who are reading up everything.
So either they are blank or either they are extra smart to think that no, they know everything. One of the two. Anyway, thank you everyone, and thank you Nirav especially for joining us, for helping us. It was a lovely session. A lot of insight on the changes in law and a lot of insight also on the recent judgments, which will definitely, I think, help those who have joined today. They have noted down the judgments, so they'll have a easy way out to answer those questions which may be asked relating to these judgments.
True. Pleasure is mine. Thank you so much for coming, and I enjoyed the session myself. And I wish all of you all the very best for your exams, and I hope all of you do well.
Right, thank you. All have a good day today, good Sunday, and back to work tomorrow.
Okay.
Right. Thank you.
Thank you.
Thank you.